rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, hear. All persons having business with the Appellate Division draw near. In the attendance, and you shall be heard. Be seated.
Good afternoon. Welcome to the Appellate Division, First Department. As I called the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People versus Kamal Dockery.
I'll request 3 minutes on the red, 1 rebuttal.
3 and 1 and 3. Simchick v. Hudson 36. You're for the plaintiff? All right. We'll go with 3 and 1 and 1. Thank you. M Children is someone here for on M Children? Number 3, M Children? Okay, that's submitted. Navarro versus Joy Construction.
Daniel Rosenblum for the defendant's appellant's respondents. I think we request 10 minutes.
Do you want time in rebuttal, counsel?
Yes, and 2 minutes for rebuttal.
We'll go with 5 and 2 and 5 and 2. People v. Sophia Fearing. Submitted. Rubin versus Sabarwal. 5 and 2 and 5. Spin Capital v. Golden Foothill Insurance. Okay. We'll give you 5 and 2 and 4. Thank you. People v. Sean Bryan.
I'll request 6 and 2.
6 and 2 and 6. People v. Pedro Vega.
I'll request 4 and 1, please. Respondent request 3 minutes, please.
4 and 1 and 3. Felton v. St. Joseph Hospital. Counsel, did you want time in rebuttal?
Defendant, appellant, respondent, Greenwood Crematory, 5 minutes.
Okay, 5, 5, and 5. Thank you. Providence Construction v. Silverite Construction. Very good. Granted. How much time do you want?
5 minutes.
Do you want any time in rebuttal, counsel?
No, he's responding.
Respond. I'm sorry. Please.
For Providence Construction in Westchester. 5 and 2. 5 minutes.
5 and 2 and 5. People v. Dominic Tarazona.
Your Honor, I'm counsel for respondent in Tarazona. My adversary advised that she would submit. I'm happy to submit as well.
Very well, counsel. Thank you. Submit. Slabakis v. Poyadjis. That's correct, counsel. Slabakis is submitted. Associated Industries versus Feronic.
The appellant 8 total, 2 for rebuttal.
5 and 2 and 5. Okay, thank you very much. First case up is People versus Kamal Dockery.
Step up.
Please.
Good afternoon, Your Honors. Harold Ferguson for Appellant Kamal Dockery. There are tremendous extenuating circumstances in this case, and it's our contention that 7 years is too much time for Mr. Dockery under those circumstances. Mr. Dockery, more than most people, well understands.
He was 19 years old at the time of the shooting.
That is correct, Your Honor.
He could have gotten a max of 25 years,
He absolutely could have gotten a maximum of 25 years.
and this is 2 years above the minimum.
It is 2 years above the minimum.
And it seems to me, counsel, correct me if I'm wrong, that the mitigating circumstances were before the sentencing court.
They were before the sentencing court, Your Honor, but we're asking this court to take another look at it. I mean, in most circumstances, people in such a situation, it's fight or flight. Most people would not have done what my client had done. In essence, what he did was save his friend's life. It ended up with tragic circumstances because he did not strike the people who were attempting to kill his friend.
But there's no indication from the facts as I saw them that they couldn't have just run away. I mean,
They were-
the other
two-
victim gestured with a weapon, with a, I think it was a knife, towards his friend, and then he shot. He could have turned around, they could have both turned around and run away.
My client was, the other individual, Mr. Perna, had crossed the street. He was in close proximity to the two individuals who were approaching him, one of whom announced, "Get him," and the other person approached with a screwdriver. My client emerges, and the question becomes, what could he have done? Most people run away in that circumstance, but there's no indication that Mr. Perna had the ability to run away at that. Only after Mr. Dockery fired did those two individuals run away. Yes, it led up to a tragic circumstance, but I also ask Your Honors to take a look at how this has become a transformative event in my client's life. Long before he pled guilty while he was sitting for over a year in Rikers Island, he recognized that he needed to change his life, and he did everything he could to rehabilitate himself while he was incarcerated pre-trial for over a year. He sought his GED. He was up to the point of taking the GED. He obtained the ability to have a number of different employment skills that he didn't have before. He reinvigorated his artistic abilities to the point that Rikers Island used some of that in its Juneteenth celebration. This is a person who has made tremendous rehabilitative strides long before there was a resolution of this case.
I didn't see anything resembling an expression of remorse over what he had done.
But he has accepted responsibility. Here, he had a potential justification defense that he absolutely waived here. He also is not attempting to get his plea back before this court. He is just looking to try and reduce the time. The question is, does he need 7 years to become a fully functioning, productive member of society? It's my contention he doesn't. 5 would be sufficient, and we ask this court to do that.
I was going to ask that same remorse question.
Very good. Okay, thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors, and may it please the court, Bridget White for the people.
Could
Defendant's
you
sentence was
address
yes.
counsel's point about his extraordinary rehabilitative efforts while at Rikers?
I don't think it's fair to characterize them as extraordinary without.
Court take it into account.
I think that's absolutely correct, Your Honor.
He completed his GED.
I believe so, because, Your Honors, as we noted in our brief, the people originally offered 10 years. The court undercut that to give 7, just 2 above the minimum, when he could have received the maximum of 25. And here, this resulted in very serious harm, and that harm should be reflected in the sentence. A minimum sentence simply wouldn't do that. This victim was struck by a bullet, was unconscious and needed to be intubated for several days, suffered life-threatening injuries, and that should be reflected in this sentence here.
And the defendant fired several shots.
Yes, the defendant fired 4 shots in response.
One of them hit someone who had nothing to do with this altercation, and that person was unconscious for several days.
That's right, Your Honor. And so for those reasons, If you have no further questions, we would ask that you affirm. Thank you.
Thank you, counsel.
I assume we're going to get beat up for this, but if you juxtapose what Mr. Dockery did with the event that happened last June on the subway when the police opened fire on an individual as close as I am to you, Justice Moulton, and fired 9 shots at the person, missed him 8 times, hit an innocent bystander on another subway car, hit another woman, hit one of the police officers, and they don't even get charged. So, I mean, when you take, you have to, I think you have to look at the big picture. It's like, did my client do something?
That's like a 30,000 feet picture, you know, that's,
Right.
I think that's not a
Right.
good analogy for you, counsel.
Right,
Please continue.
right.
But again, Your Honors, I believe, I mean, his life has changed. His significant other gave birth while he was
His first child.
What?
His first
his
child.
first child. They have been in constant communication with me throughout the pendency of this appeal, and they wish to, you know, become a family, and we would ask this court, in the interest of justice, to reduce the sentence to the minimum term. Thank you, Your Honors.
Thank you, counsel. Thank you both. Simchick v. Hudson 36.
May it please the court. I'm Thomas Catalano, Lester Schwab, Katz and Dwyer, for Horsepower Electric. As I'm sure the court's aware, there's no opposition that's been filed to our appeal. This is a case involving new construction. We represent the electrical contractor who was
I mean,
based.
it seems pretty clear that your client would have been the only person having that particular kind of cable at the work site. But your argument is more that, how did it come to be on the staircase? We don't know.
Exactly.
Is
Your
that
Honor.
it?
I mean, that's basically it. And, you know, as I'm sure Your Honor's aware, we put all of this debris, what he basically fell over, was something that had to be done in order to make the connection from the BX cable to the various parts of the apartment.
Let me just ask you, how do you think you made your prima facie? What did you submit to, because it's your motion, right?
Yes.
So how did you make your prima facie to show that you weren't responsible for this cable?
Well, of course, Your Honor, it's hard to prove a negative like that.
I agree. So that, so that's
That's sort of the nature of summary
But at the
judgment, though,
same
counsel.
time,
right? So what did you put in to show that you weren't the person who?
It's really be impossible to do that, Your Honor, but the cases we relied upon, and I'm sure Your Honor's aware of all those cases involving speculation, that the jury would just be left to speculate. How
Well,
did this,
what about the fact that it's your cable, right?
it's my cable, but how would it get there? If you have all this,
So how did you prove that it didn't get there because of you?
I put in the testimony indicating that we always put old debris like this in the middle of the place.
And it wasn't your responsibility to clean it up.
Right. We basically, they came around and
Where were you during the days prior to the accident? Where were your people?
we're nowhere near that. We basically submitted different floors, about
But
3 or
wasn't-
4 different floors, nowhere near this.
Wasn't there testimony by, I think, Mr. Kimmel, one of the foremen, that the company had done work on the 11th floor, and where Mr. Zimick fell was between the 10th, I think, and 9th.
Yeah,
So
exactly.
doesn't that create a possibility of there having been BX cable that was used on the 11th floor that made its way into the stairwell?
Right, but as we indicated in the motion, we were nowhere near the 11th floor. We listed all of the floors that we were at in the motions, and we were nowhere near the 10th or the 11th floor. And
Oh, I thought that Foreman Kimmel specifically said that there was work being done on the 11th floor within a reasonable amount of time before the,
I respectfully disagree, Your Honor. He didn't say the 11th floor.
so your position is essentially that,
Sorry?
your position essentially is that you weren't working anywhere near there and you cleaned up after yourselves, and when you cleaned up after yourselves, it never resulted in stuff being left in the stairwell?
Yes, exactly. And also other people, the plaintiffs themselves testified there was sheetrock, what you call scraps, pieces of paper, things like that, something we have nothing to do with. The more logical explanation is that the people who were supposed to clean the stairway dropped something. There was testimony that we also submitted from the principal of the labor company, Quality Facilities, that they use the stairway to transport garbage. That's the explanation. I mean, it'd be pure speculation to think that somehow one of our guys,
So Kimmel testified that if you had left any debris, you would put it in the room next to the staircase, correct?
next to,
Kimmel.
Yeah, you would put the debris, you would take the debris off the staircase and put it to the side,
no,
correct?
never, no. We don't.
Kimmel
The
didn't say.
testimony is that we didn't even work in the staircase. We're working, the staircase, basically, we didn't work on it at all. With
Counsel, we're trying to understand how a BX cable is on the staircase.
Exactly, Your Honor. If BX
So
cable,
it makes sense if Kimmel says, when we work on things and we have debris, we put it to the side for the cleaning people to pick up.
and Kimmel also said that he never worked in the staircase, that actually the BX cable was actually poured, with concrete was poured over that. So he said his exact words were almost never. They don't use BX, they don't work in the staircases. They work in the apartments, hooking up the BX cable to the switches, to the light switches, to the outlets. They don't work in, they had no reason to work in the staircase where everything was, with the contract, with the cement was all poured in over that. So they're nowhere near the staircases.
But Mr. Kimmel did say on 560 of the record that they were working on the panel on the 11th floor on the day where the accident occurred. And if other individuals besides the person who was injured had to wait a long time for the lift and decided to walk down the staircase, couldn't that have I mean, it seems to me that would be a plausible explanation for how the BX ended
If he's,
up there.
if he's below that and someone was going up the staircase, I mean, it's just speculation, Your Honor. That how could anyone, and we didn't work in the staircase. And plus there's other garbage there. It's solely the responsibility of the construction manager who brought us in to clean those staircases. And they're solely responsible, they're solely liable, and we were not there.
The cleaning contractor has been let out of the case, right?
Quality
Quality's
Company
not in the case
Services,
anymore.
they were let out of the case on the theory that they were basically just supplying bodies, just supplying laborers, and they were supervised
Oh,
directly
right.
by the construction manager.
Any other questions? Thank you, counsel.
Thank
Good
you,
time
Your
rebuttal.
May it please the court, Christina Mercado, Block O'Toole Murphy for plaintiff respondent. We're named as a respondent, but as we say in our brief,
You just came to make sure that we didn't do
I
anything.
just
with the
wanted to make
240
sure that.
Counsel, let me finish the question, just so I'm clear. You got a liability finding on 241 sub 6, right?
Correct.
And you want to keep that.
I do want to keep
I don't think it's in any jeopardy in
Thank
this
you.
appeal.
just in case it's ever happened to it again.
Is there anything else you want to say?
Can I just ask you,
It's a question.
your client never testified that there was anyone from the appellants near the staircase on the day of the accident, right?
No, but he testified that no one at all.
Right, but I mean, obviously, he walked down the stairs, he would have, if there was someone there from appellant working in the area, I mean, maybe.
At that very time, I mean.
Right, but, well, I mean, that's the only time, right? We have to know if that's when the accident occurred, right? So when he didn't testify to anyone from appellant being there, right? No. Okay.
Right, he didn't. And again, we don't have any direct claims against them, so I really don't want to surprise them in any way by saying really anything at all. So, thank you.
Thank you, counsel.
Thank you.
Nothing further to say? Okay, any questions? All right, thank you, counsel. Thank you both. Next case up is Navarro versus Joy Construction.
Good afternoon, Your Honors. Daniel Rosenblum from Kahana and Feld for the defendants, appellants, respondents. So there's a lot going on in this case, obviously more to address than in 5 minutes, so I suppose I'll begin by asking if you have any specific issues that you would like me to focus on.
You go ahead, counsel.
Okay, so I'll actually do something a little unusual and begin by talking about a couple of very recent cases that came out 2 recently to be in the briefing, but kind of speak to these issues and have a contrast between certain lines of cases that plaintiff's counsel relied upon in his brief and what's going on in here. The first being Medeiros versus 147 Amsterdam LLC. That's a First Department case in April. And it's the latest in a long line of cases stating that in situations where we don't know precisely what was wrong with a scaffold, but know that no matter what, it wasn't supposed to collapse, almost draws a res ipsa inference against the defendants and state that that's a presumptive violation of Labor Law 240. There are many similar cases in plaintiff's brief. Another similar one is Wilson versus AC 320 Hotel Partners that came out just, I think, a week ago, where the plaintiff...
Counsel, your opponent's point is regardless of the initial cause, it was the violation was your failure, your client's failure to provide necessary safety equipment.
Yes.
And roof lines were one issue, which you made a great deal of in your brief. You talked about them using Richard Nixon-esque passive voice, which I thought was impressive, although
Thank you.
perhaps you're talking to an older demographic when you use that locution. But they say that you particularly focus on record 247, 246, which is the EBT of the plaintiff, talking about roof lines.
Yes.
And saying that it would be impossible for two people to tie off on roof lines. How is the affidavit contradicting that? Because it sounds like in the affidavit they tried to make clear, and clarification's okay, that 2 roof lines would have been sufficient for 2 people to work on the scaffold in question.
Yes. So,
At the EBT, in other words, he says, I was talking about 1 roof line. I didn't understand the translator. And even you admit that the translator did not a great job at the EBT. You said so in a footnote in your brief.
Yes.
So, what about that? It doesn't that...
So, yes.
So no roof line
Why can't that just
liability.
be a translation issue, and why is that a direct contradiction? So, first of all, when the translator was having issues, it was translating sentences from the plaintiff into English because of his dialect. There was no issue on the record translating counsel's questions to the plaintiff. So for plaintiff to say that this was a mistranslation, there's no basis for that.
How do you know that there was no problem with the translation unless you speak the language that the translator was translating into?
Well, Your Honor, if we're going to be able
I'm
to
just asking,
yes, plaintiffs who speak, or witnesses who speak in a foreign language, we must be able to rely on the translation. Now, plaintiff's counsel was there, and if he knew that roof lines were an issue, which we must presume that he did, if in fact this was what happened, then where was he to correct that record? That is a damaging sentence that the plaintiff said, that roof lines can't be used when their entire 240 claim is premised on failure to provide roof lines.
Well, is there any
Why
dispute
wait
that
for years?
Is there any dispute that he did not have the roof line?
There is no dispute, no. But plaintiff's testimony makes clear his answers were responsive, his answers were logical, that 2 roof lines could not be used when more than 1 person was moving in an enclosed space.
I didn't think he was asked whether 2 separate lines could be used for 2 people working on that, in that space.
Defense
I don't
counsel
recall
used the
his being
plural.
asked that, and it seems to me that you're suggesting that he was providing an answer to that question, but I don't think it was ever asked.
Well,
Which actually surprised me on your client's end.
Well, Your Honor, if it had been pleaded, then perhaps we would have known to ask more about it. But roof lines were never, it was never known that that was an issue in this case. Plaintiffs said that they might be able to be used. Counsel clarified that they could not be used and moved along. But that wasn't a
Counsel clarified that at what point?
I'm sorry?
Counsel clarified that at what point?
Well, he asked, so roof lines wouldn't have been useful to you, lines plural. Plaintiff said no, and then counsel moved along. A failure to provide roof lines.
Plaintiff's counsel asking that question?
I'm sorry?
And that was plaintiff's counsel asking that question?
That was defense counsel.
Okay, so you just said that he made that argument. I don't see how that's making that argument.
I'm sorry, Judge, I think we've kind of lost track of the
Go ahead.
question. I see that my time is
Please
up.
continue. You can, if you want to clarify that, or if you want to, it's an interesting case. I'm not
Yes.
sure I gave you enough time, so if you want, you have one more minute.
Sure. So what I meant when I made that argument, when I said that if we had known to ask, we would have gotten more into it, roof lines, the failure to provide roof lines was not an allegation in this case until plaintiff's reply on summary judgment. So counsel didn't know to focus on that issue during the deposition because failure to provide roof lines had never been pleaded, had never been elucidated.
Is that an inference that you should draw, though? Because they did talk about not being, he had a harness on, he had whatever you would use to clip on.
Yes.
To the actual scaffold, and that was not effective, I guess, or wasn't able to be used. Doesn't that give you a heads up that roof lines might become an issue? I mean, it's not that big a leap, it seems to me, but tell me why I'm wrong.
Not when he testified that they couldn't be used.
Well, but that gets you to the question of whether what he was answering was whether one line could be used for two people. And if that's what he thought he was answering, then it doesn't answer the question of whether two lines could have been used successfully for two people.
Well, Your Honor, it sounds like in that case that defendants would be punished for not doing an investigation to find specific grounds for plaintiff's case when plaintiff should have pleaded it in the first place.
No, wait a second. You had a deposition. Your client asked him, did you tie off, right?
Yes.
So you weren't surprised. Why would anyone ask the question, did you tie off, unless there was an issue about tying off? This idea that you had no idea that this is based on your questions. No, I didn't tie off. Why didn't you tie off? Because there was no place to tie off. Why was there no place? It was, I never was provided a roof line even when they requested them. That was the testimony that your client elicited. It didn't come out of nowhere. So this idea that you had no idea that this was going to be an issue doesn't really ring right.
And then upon further cross-examination.
Okay, but that's a different thing than saying we had no idea that this was something. Your client specifically asked and was given these answers. So you can't now pretend that you didn't think it was an issue.
All right. Well, in that case, Judge, I'll say one last thing, and then I'll give my opponent the podium. Roof lines should never have come into play here. Plaintiff should never have been 8 feet off the ground. He should never have been on the scaffold without OSHA planks to form a floor. He should never have been on the scaffold without guardrails to protect him from falling.
But he says the reason that happened is because the drawings that they were given didn't take account of the tree, which made it impossible for them to take the next step.
Well, even if the tree impeded on the work site, that is not a 240 violation.
No, but it's not a 240 violation, but that in itself is not a 240 violation, but it may have led to the situation that you're claiming no responsibility for.
Which was an intervening cause, Your Honor.
Counsel, we can talk about that on rebuttal. Thank you.
Sure. Thank you.
Good afternoon, Your Honors. Kenneth Gorman for the plaintiff respondent appellant.
Your opponent points out, and Justice Bluth found, that there's an issue of tribal fact about whether your client was the sole proximate cause of his injury. He was a supervisor, correct?
That's correct.
He was supervising the crew that day.
That's correct.
So he was making choices about how to assemble the suspend scaffold, right?
That's correct.
So why wasn't he the sole proximate cause?
Because he testified clearly that he couldn't assemble the scaffold under the tree branches. He could raise the scaffold's plank, the scaffold's base above the tree branches, but when it had guardrails installed around it, all four sides, he couldn't.
Yeah, but ultimately he comes down to saying that he fell through the scaffold, is that right? Not over the side?
Yes, he testified that he fell.
You kind of commit to that finally in your brief, that it was through the scaffolding, the bottom of the scaffold,
That's
right?
correct.
So why couldn't he put how would the tree impede his ability to put the planks down vertically in the scaffold?
Well, he testified that if he put the planks down, if he put the guardrails around the scaffold while it was on the base of the sidewalk bridge, he wouldn't have been able to raise it because the tree branches would have been.
No, we're not talking about the guardrails. We're talking about the planks that he fell through.
Okay.
Why couldn't he put the planks in?
He testified that he had there was a raise in the plank. But assuming that he fell off the edge of the scaffold.
No, but he, that's the whole thing. You commit to the fact that he fell through.
Testified that he fell
Right?
through, there was a,
So that's the testimony.
there was a gap in, he testified that there was a
Yes,
gap.
so
and he
that's
fell
where he
through it.
fell. So let's
That's correct.
assume that he was telling the truth when he testified to that. Why couldn't he put the planks in?
I don't have an answer to that question. It's not really clear on this record as to where the gap, I mean, the gap was in the middle of the platform he testified to, but he didn't.
So then why are you seeking summary judgment if the reason why he fell was he fell through the planks that he himself didn't put on the bottom?
Because he wasn't given an appropriate anchorage point. Had he been given an appropriate anchorage point to tie off to, he would never have fell to the bottom. His fall would have been, he would have been prevented from falling.
And when did you first raise the issue of the anchorage point or the roof line?
He testified to that at his EBT.
Was it raised in the pleadings before that?
I don't believe it was raised in the pleadings, but this is summary judgment. He's not confined to the pleadings. Testimony does play into it. And he testified clearly at his EBT that roof lines were not provided, and had they been provided, he would have been able to tie off.
And what about counsel's point that your client indicated that it was not possible to have multiple, there were 3 people on that scaffold, that they could not all have been tied off?
Well, he testified, I mean, it was pretty clear that he thought that they were testifying about one line, not more than one. But assuming that was the case, there's no reason why he couldn't have worked on the scaffold alone, or workers should not have been permitted on that scaffold until the guards were installed. And if that was the case, he would have had no issue with the roof line had it been provided. Any other questions? I'll rest on my brief. Thank you.
Thank you, counsel.
Okay, just to quickly address 2 things. The statement that people shouldn't have been allowed on the scaffold, that there should have been only one person on the scaffold, that if that had been the case, the plaintiff was in charge. The plaintiff was the one making those decisions, and therefore imposing strict liability on anybody else for decisions.
Well, let me ask you this. How do you respond to counsel's assertion? If he had been tied off, didn't matter whether there was side rails, bottom rails, orange rails, green rails, he wouldn't have fallen.
Well,
Is that not correct?
I would say that the opposite is true also. That
I'm
if
just
he-
asking you, if he was tied off, is it correct that he would not have fallen 8 feet?
Probably.
Yes, okay. And the testimony is he wasn't given the line to tie off, correct?
That's true.
Okay.
But one last thing, and then I'll rest on my papers. Counsel's failure to answer why he couldn't install the planks when the planks would also have prevented his fall better than a roof line says everything this court needs to know about this case. They were there, they would have prevented it. He had adequate safety equipment to prevent the fall that he did not use for reasons that he cannot explain. And that should be the end of this analysis. Thank you.
Thank you, counsel.
Just briefly, at best, the failure to properly install the planks constitutes comparative fault. No matter how much fault the plaintiff was at, it's comparative, and comparative fault is insufficient to beat summary
How is that
judgment.
the case, counsel? Because if the planks are a safety device, you put them underneath the scaffold, the floor of the moving scaffold, and he was provided them, and then he didn't install them, and then he fell through them.
Because it goes back to the anchorage point. Had he been given an anchorage point, he would not have fallen to the ground.
Well, in other words, you might not have had to elevate. It's still a question in my mind anyway, that why did you have to elevate the scaffold, the moving scaffold in the first place? Why not put the planks on while it's on the sidewalk bridge?
He might have, I can't answer that question, as I said, but he could be at fault. The plaintiff could be at fault for not putting the planks on the sidewalk bridge when it was laying there, but he was not at fault for not having the appropriate anchorage point. That wasn't given to him. Had the rope guard been provided, he would have had an anchorage point. Thank you.
Thank you, counsel. Thank you both. Rubin versus Sabarwal. Please.
Good afternoon, Your Honors. May it please the Court, Ethan Leonard for the law of Neil Brickman for the plaintiff appellant Shelley Rubin. As a result of discovery, there's no longer any doubt whatsoever that defendants did not provide Mrs. Rubin with the jewelry that they told her they were providing.
But she also took no steps to find out anything about the jewelry, which I could understand if a friend was giving you a piece of jewelry for $20, you might not follow up on it, but she spent millions and millions of dollars, and it never occurred to her to look into what it was?
Well, Your Honor, for a period of time, she became friends.
Right, but the first transaction occurred very soon after they met, so her utter reliance on this woman, and I want to remind you that this court, in dismissing the fraud claims, basically said there was no good faith basis for her reliance on her friend.
Yes.
So you're really asking us, it seems to me, to take a different position than our court took in the earlier decision in this case, which is not our normal practice.
I understand that's not the normal practice, Your Honor, but there also was discovery that occurred in the interim, which changed several aspects of that. The initial decision was based on a complaint, which was based on allegations that our client had represented that Mrs. Sabarwal had made to her, including as to the age of the pieces, the provenance of the pieces, and various other matters, if I might. What we now have is Mrs. Sabarwal admitting that everything that she put on the invoices, she represented to Mrs. Rubin, so both verbally and in writing. And we know that the expert, not our expert, defendant's expert, has said that 25% of the pieces that are at issue here were misrepresented. In other words, he has said when they were called...
What has that got to do with the unreasonableness of the time for, under the UCC, rejecting the goods? That has nothing to do with it. So the discovery that you now think you've got doesn't change a single thing. The question is, one, under the fraud standard, whether you have reasonable reliance, which your assertion that there was a misrepresentation doesn't change that result, and two, that you waited unreasonably long under the UCC to reject the goods. Why don't you deal with the reason why your case was dismissed below? Because all that information changes nothing.
So absolutely, Your Honor. And reasonable, whether a revocation is reasonably timely is usually a question left for the jury, right?
Except under certain circumstances, like 2 to 3 years, has been held many, many times as a matter of law unreasonable.
No, the timing absolutely is extreme in this case, Your Honor.
So why is it not unreasonable as a matter of law?
Because in this circumstance, there were no separate... The case law is clear that without other explanations, that when there's no other inference that can be drawn, then a long period of time like this would be. But in this case, each of the pieces, you need an expert to understand them. This wasn't something where she could look at it and tell. In fact, they took it to experts for alternative purposes, and they didn't tell. It was only until June of 2016 that she learned for the first time that what were represented to be rubies were not rubies, diamonds not diamonds, emeralds not emeralds, etc. That was the first time she knew of it. Within weeks, she contacted counsel, retained counsel, and requested rescission. Rescission was denied. Those facts aren't denied. So she did act very, very promptly and reasonably under the UCC as soon as she learned. There was no way she could have learned.
Nothing prevented her from having learned that much earlier.
$18 million. $18 million.
And I understand.
She could have gotten it appraised a month after, 2 months after, 3 months after. In fact, the case law that you cite in your brief says less time than what your client took is unreasonable.
Absent other circumstances. And in this case, this other circumstance, she needed an expert to do it. The cases that are cited are
She
places
could have
where
gotten it. Nothing prevented her from getting an expert.
You want us to let this go because she was friends with the person that gave her the jewelry.
Not only that, she was an expert. She held her out to be an expert. She relied on her. as an expert, and that's what the question of reasonable reliance is. That should be a question of fact for the jury, Your Honor.
But when you're
I'm not
talking about
saying this is
reasonable
a- I
reliance,
didn't-
excuse me, but when
Sorry.
you're talking about reasonable reliance, you also have to acknowledge that your client was the founder of a museum that specialized in this area of art.
Your Honor, if I may, my client is a philanthropist. She was duped. She bought stuff that she believed, and she paid prices that she
was the
believed
founder
were
of a
genuine,
museum.
real- Sorry.
She was the founder of a museum, co-founder of a museum that specialized in this form of art.
No, it was in art, not in jewelry, and not Indian jewelry. And she certainly is not a gemologist, and there's no allegation.
More of a reason for her to get an appraiser if she's not a gemologist.
Your Honor, I understand there is a lot of money here involved, and a lot of money that was spent.
The money's not the issue, counsel. It's the time that she took to look at what she paid for.
With all due respect, money has been raised by this panel 3 times now.
Yeah, because if you're paying $18 million, I want to make sure it's a real Gucci and not a fake Gucci.
I understand,
See that?
but if I walked into Tiffany's and bought it, I would not be expected necessarily to go next door and have it appraised. The question is, that's a question of fact, whether that act was reasonable. It's not the exceptional circumstance. There's no explanation for it. And that's what the case law looks for. It says,
Thank you, counsel. You have time in rebuttal. Do you have another question?
I just have one quick one, right? You're saying in late 2014, she did retain someone, right?
in late 2014.
She retained someone, and that appraisal never happened, right? And then she went till
If I might,
September
it was Gurjohn's, and she went, she had a few pieces from a prior collection.
Yes,
Sorry.
but, so that never finished, that was never, the appraisal was never completed.
Right.
And then the next time she raised it was September 2015, right?
That is correct.
So, all right, so clearly, as of late 2014, something was going on, and then she waited 9 more months.
Your Honor, if I might.
So when you say to me that within weeks, I don't think that the record reflects within weeks. That's my point.
Your Honor, may I address that?
Sure.
Please.
Yes, if that's okay with
That's fine.
the JP.
At the time, they were looking for it to resell the jewelry or a piece of jewelry to finance a different matter and for estate purposes. They didn't take it to a gemologist. They went to Gurjohn's to get an appraisal of the jewelry, not to see if the pieces themselves contained what they were alleged to contain in terms of composition, in terms of rare gems and gold, as opposed to
But I'm
being
not
base
really
metal.
sure why that matters at all. She took it to be appraised, and it never was. And then 9 months later, she took it to someone else.
Because her intent, and that goes to the
Her
reasonable
intent really has, okay.
Well, it does. Thank you, Your Honor.
You have time to rebuttal, counsel.
May it please the court, Paul Sweeney from Sir Tillman Ballin on behalf of the respondents. As your honors stated, the primary issue here is revocation, whether the revocation was timely under the UCC, and under the UCC, we look at reasonableness. And some of the arguments you heard from appellant's counsel, he's talking about, well, after we found out in 2016 that we believed the jewelry was not what we had thought it was, we acted quickly. But that was years and years after the sales had taken place. Years after, by
Counsel,
her own
would you
admission in the
concede
complaint.
if she had more timely objected, it does seem like that there's evidence in the record that the jewelry did not conform to what the invoices said it was.
Well, of the...
Right? I mean, you could say that it's just a matter of timeliness of her objection.
Well, not just...
At least an issue of tribal fact, because you have the IGI reports about whether or not these things had actual gemstones. So that would create an issue of tribal fact about nonconformity anyway, right?
No, Your Honor, for the vast majority of the pieces. The only expert who looked at the actual pieces of jewelry is the respondent's expert. Plaintiff's expert did not. Of those, we admit there are issues of fact with regard to 8 pieces of jewelry. Our expert looked
Are
at
those among the 51 that are within the limitations period?
51 within the limitations period. 32 of those, only 32 of those were presented for inspection. We have no idea where the other 19 went. And of those 32, we can see that there's an issue of fact as far as consistency with the invoice of 8 of them. That's it. So the vast majority.
So then how do you explain the discrepancy between the $18 million sale and plaintiff's appraisal of $1.8 million?
Well, there are a couple things, Your Honor. These
And that's not a small discrepancy. It's, you know what I mean?
no, but Your Honor,
Well, how do you explain that?
because she bought what she was told she was buying. It was custom-made art, jewelry that was put together, and then the appraiser broke it down and said, if you break it down into its component pieces, I think it's only worth this. She bought the art and she testified at her deposition because she loved the look of it. It made her feel glamorous.
So you're saying that she bought the artist's
Correct, and
work
she put
as
the value on
opposed to a gem worth this amount of money or that amount of money, right? So maybe if someone bought a painting, someone could say, well, that painting, if I took the paint, it would only be $18 worth of paint, but it might be a Rothko's vision would be worth $8 million. Is
Absolutely,
that your point?
absolutely.
Okay.
And that is the plaintiff's own testimony, is she bought it because of the beautiful aesthetic of it, which didn't change. She wore it all during this time period. She gifted items to family members and friends. So it was her value that she put on it as well. But to go back to the original question, the vast majority of the pieces were absolutely consistent with the invoices, as our expert, the only one who actually looked at the jewelry, not the plaintiff's expert, they were consistent with those invoices. And the untimeliness of the revocation, which happened years afterwards, years after she said in her own, again, complaint and deposition testimony, I began to become suspicious in 2014. I started an appraiser, but she stopped it. And then she waited until later, and the alleged revocation didn't happen until 2 years later. That, under the UCC, as a matter of law, 2 to 3.5 years is too long to revoke your acceptance. That is in the case law that we cited. That's in all the case law that the plaintiff appellant cited. It's clear that that amount of lack of diligence, which this court found when it affirmed the appeal of the motion to dismiss, that she showed she's a sophisticated buyer. And by the way, in response to plaintiff's statements, you don't have to be an expert to be a sophisticated purchaser. She's a sophisticated purchaser. She owns a museum of Indian and Himalayan art. Doesn't mean that she's a gemologist or an expert, but the standards under the law are you a sophisticated buyer? And of course she was. Of course she was a sophisticated buyer. And she had no basis under the case law to just say, well, I became friends with the seller. I had an arm's length transaction at the beginning, but I became friends, and therefore I have a special relationship, and my lack of due diligence is excused. That is not the case law. The cases that we cite in our brief clearly say that under those circumstances, you are not entitled to rely on this special relationship, which, by the way, applies to fraud cases, negligent misrepresentation cases, not the UCC cases that we're looking at today.
Thank you, Counsel.
Thank you.
If I might, very quickly, a few quick points. Mrs. Sabarwal designed this jewelry solely to make it more reasonable for her to believe. She didn't use lightweight stuff. She used heavyweight and then surrounded it with gold cover, gold gilt, to make it feel like it was gold because of the weight. No, but this goes to my client's reasonableness and the timing of it.
Is counsel correct that your expert never actually looked at, examined the jewelry itself?
Defendant's expert never analyzed the jewelry.
I'm just asking you whether your client did your client ever actually look at the jewelry?
Did my expert?
Yeah.
No, he relied on the IGI reports, which are the very same reports that defendant's experts on.
He never inspected, or she, I don't know if it could be a she.
Mr. Palmer.
Never
He
inspected
some
the jewelry?
pieces, but his report was based on the analysis that IGI, the experts in the field, provided. The very same experts that defendants expert relied on. The defendant's expert didn't do any specific analysis.
But did defendant's experts actually inspect the jewelry?
Absolutely, and he admitted that in 25% of the ones he looked at that are referenced, that are now at issue in this case, did not meet the expectation. And it's not, we're not talking about, the misrepresentations here are only that the contract that was given was not what was provided.
Counsel, can you go back to the point that counsel made and that my colleague had asked, that in the first Rubin one, there was a determination that your client did not get an appraisal soon enough, so there was no fraud. Can you tell us again what is different now?
So there are two things. One is in terms of the timing for the fraud and the reasonableness is a different standard, as counsel just said, than for under the UCC. So on that basis alone, it's a new analysis. May I continue?
Please.
Okay. Secondly, because of the context, and I think if we go back and look at the decision on the underlying complaint, on the initial decision on the motion to dismiss from both the lower court and which was affirmed by this court, it was looking at the allegations of fraud that were in the complaint. And it was basically said, we don't believe that on these 80 occasions, these 5 representations were made. And therefore, the fraud and the reliance on these statements, on these contextual statements, couldn't be made. Now we have a specific admission from the defendant as to what representations were made and a specific analysis from defendant's own experts that some of those did not meet what was actually provided. So the breach of contract under the UCC is a different standard than under the fraud standard. And in this case, the reliance wasn't on to meet the fraud standard. It was on whether, in fact, what was put in front of her, she could believe both the written statement, the oral statement, and what the things looked like.
Thank you,
without going to the experts. Thank you, Your Honor.
Thank you both. Spin Capital v. Golden Foothill Insurance. Please.
Good afternoon. Shane Heskin on behalf of Appellant Stefan Lear. Your Honors, I've been practicing law for 25 years, and this may be one of the most bizarre cases I've ever seen. And I hate to do this to you, but I feel compelled to raise another jurisdictional issue that has come forward since the briefing in this case and just developed.
Counsel, that might be to horse the record. I don't know if we can consider that, but
well,
you're welcome to invite us.
It's in the underlying record below, where there's a rule that you have to be represented by counsel if you're a corporation. The plaintiff in this case is no longer represented by counsel. They've withdrawn as counsel. The court's ordered it.
Who's the gentleman sitting to your right?
That's counsel for the receiver. There is no counsel here for the plaintiff, underlying plaintiff in this action. They've all withdrawn as counsel. The court's ordered it. As a corporation, you have to be represented by counsel.
But that issue is not before us. We have in front of us 2 counsel representing 2 adversarial parties. We will decide it based on your arguments. I don't understand why you think that we should now intervene in what should have been raised in the trial court.
It's a recent development that's happened.
Counsel, that doesn't change the fact that it's not before us. I think you should stick to what's before us.
Sure, Your Honor. Listen, I appreciate that. I think jurisdiction always has to be there, and I think I have an obligation to raise it. That's all. And let me just point for the record, just so that you have.
Are you saying that the receiver doesn't have the ability to defend the finding of contempt?
I think there's the underlying plaintiff has to have counsel in order to bring the case, and there's no case. And on top of it, there was a.
Counsel, you can raise that in the trial court, but not here.
Yeah. All right. I mean, you did raise a jurisdictional question about this, the summons not being served on LS 10.
Yes.
Do you want to talk about that?
So to this day, there has been no summons issued.
On the other hand,
You submitted.
What's it called? Life Shares 1019 was one of many of the defendants who jointly filed an answer. He filed an answer. It was one of the parties filing that answer. That answer did not raise lack of personal
Also, it had
jurisdiction.
counterclaims too, right?
And it had counterclaims in it, so he has availed himself of the court. It's a little late to raise personal jurisdiction, and the issue of not having been served with the summons is not a question of subject matter jurisdiction, but personal jurisdiction, which Life Shares 1019 clearly waived by its answer. So I wonder whether you have any other arguments.
Sure. So, Your Honor, I would respectfully disagree that it's an issue of...
Counsel, I suggest that you move on to other arguments.
Okay. As to
I'll waste your time.
the personal liability here, Mr. Lear was acting in the capacity as the CEO and president of Life Shares 1019. At the time that he took the actions, he relied on counsel. He got separate counsel. He had separate counsel look at the issue. The first thing they did is they said...
He submitted the claim for payment under the policy on the life account, on the life insurance account, and there's nothing in the record that establishes whether he did that in his role as a member of the LLC or whether he did it on his own, but he did it on his own. Nobody directed him to do that. I don't understand why he can't be held individually liable for that.
Because you'd be piercing the corporate veil, and there's no piercing the corporate veil claims in this case, and corporations act through their employees. The only way he could have done that is he was acting as the CEO.
You'd have so many people avoiding contempt if that was the law, counsel. That's not the law. He was aware of this court order and he violated it, it seems like. Tell me I'm wrong.
Stefan Lear, if anyone violated it, it was Life Shares 1019. Stefan Lear acted in the capacity of Life Shares 1019. He did so on the advice of counsel. He had a fiduciary duty to act in the best interest of his shareholders.
But the receivership order specifically said all parties shall assist the receiver, not undercut the receiver, and he violated that order.
He is in this case because he's a personal guarantor. He does not have the authority. Stefan Lear would not have the authority to direct the payment. Only the CEO and president of Life Shares 1019 has the authorities to direct payment. Stefan Lear does not have that.
So are you saying that if he was doing this on behalf of the corporation and he knew that there was a court order which he was violating, that he's not violating it because he's doing it on behalf of the corporation? That's an extraordinary result, and I don't think any of us would be comfortable in issuing orders that we thought people could so easily avoid.
Well, it should be, if you're doing it in the capacity as a CEO, you should be treated in that capacity. And
insulated from violating an order that clearly applies to you as an individual party to this action?
Here's the thing.
And the court gave him an opportunity to purge it.
It was too late at that time. So once the money was directed to Life Shares 1019, it was distributed. After that, you couldn't unwind it.
And the court asked for documents to show that were never provided, counsel, correct?
We did provide some documents.
Where is it in the record? Can you cite a number for me so I can look it up?
I can't recite it by memory. I apologize, Your Honor.
Thanks, counsel. You have time, rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Brendan Scott, Claysett, Winters, Druther, Southern, and Stevens on behalf of Fred Stevens in his capacity as the receiver.
Could you address the issue that counsel's raised about Mr. Lear's individual responsibility when he was allegedly acting on behalf of the LLC, not for his own?
Yes, well, we did cite a couple of cases in our brief, the Citibank case and the Vatswin case, which found essentially exactly what Your Honors raised, is that you cannot hide behind your role as a director or officer when you knowingly violate a court order.
There's no doubt that he himself was bound by the court order, correct?
Correct.
And he didn't have to put in an application for the proceeds. You put in an application for the proceeds, correct?
The receiver put in an application, Mr. Lear put in a competing
Right.
application.
So he didn't, so he could have simply done nothing and complied with the order, right? The corporation didn't have to put in an application for the proceeds. And if it was going to do so, it couldn't do it through AI. Someone in the corporation had to do it, right?
Correct.
And that person, if that person, and it's been a long time legal principle, that a officer of a director who themselves commits tortious acts can be held individually liable for their own tortious acts, even though they're acting in the capacity as a representative of a corporation, right?
Correct, Your Honor.
So there's nothing weird or freaky or unusual about this case today. This Mr. Lair, who was individually bound by the order, violated the order, committed a tort, even though he was doing it in his capacity as an officer of a corporation, he can absolutely be held individually liable. Tons of cases saying that, right?
That's correct, Your
All
Honor.
right.
And that's exactly what the trial court found, that Mr. Lear had assisted in the violation of the order in whatever capacity he did it in. He knowingly assisted in the violation of order, as he was a party, John Hancock was a party, and we believe LS 1019 was clearly a party. I don't know if you want me to...
So, counsel, wouldn't it be fair to...
No, it's okay. You go.
That the issue here isn't piercing the corporate veil, but that Mr. Lair was seeking the shelter of the corporate veil when he's not entitled to it as a matter of law.
That's correct, Your Honor. And we did cite some cases in our briefs. I found a case as old as 1905 that said exactly that, and it picked up on what the presiding justice said, is if that was the law, people would be evading liability for contempt every day.
Then we'd all incorporate and do whatever we wanted to do.
So I think the trial court was clearly correct in finding him to be in contempt individually. I think the record was sufficient.
Gave him an opportunity to purge.
And it's
Yes.
his
Correct?
actions. It was his actions.
Correct, and it in fact extended his time to purge. At his
Actually,
request.
they reached out to the receiver and said, we'll do it by January 10th, correct?
Correct,
By
and he
January
indicated-
12th, you still hadn't received the proceeds,
Correct, Your Honor.
forcing you to file your order to show cause on January 18th.
Correct, Your Honor.
Thanks, counsel.
Thank you.
Thank you, Your Honor. Just quickly, I would respectfully submit that my client acted in good faith at the time that he was made aware of he retained separate counsel once the John
I don't
Hancock.
understand. Is it your position that he didn't apply, that he thought that the receivership order that said all parties shall assist, or I forgot, not interfere with the receiver's gathering of the assets, and he believed that his conduct was not a violation of that in good faith? How is?
Yes, and
Where is that shown in the record?
It
Where is that shown in the record?
was in the opposition, and so and it.
I'm sorry, in what form?
And at oral
I'm
argument.
sorry, in your memorandum?
In the affidavit, I believe we.
His personal affidavit saying, I believe that this was not a violation of the order? He actually said that in a sworn affidavit?
I don't remember exactly what he said. I know I argued this to the court below, and this is, so let me just see if as quickly as I can. The policyholder passed away. At that point in time, the proceeds had to be paid. At that point in time, he retained separate counsel for Life Shares 1019 because those proceeds had to be paid to Life Shares 1019.
Well, no, that's not what the court's order said.
Well, I understand that. So at that point in time, he had independent counsel look at it. Independent counsel looked at it and said, where's the summons? The court, the independent counsel
Oh,
said,
did independent counsel actually put in an affidavit that said that I advised Mr. Lair that because there was no summons, even though he had answered and counterclaimed, that he didn't have to comply with the court's order?
I think he actually argued that at the hearing. He did. So his argument was, there's no subject matter jurisdiction. I understand this panel seems to disagree with that, but it was his belief, looking at it fresh, that there was no subject matter jurisdiction, and therefore LifeShares 1019 was not subject to the order because of the lack of subject matter
Notwithstanding in the fact that it filed an answer and participate, and an answer and with counterclaims and participated actively in the litigation. He
I
got-
understand that.
Independent counsel knew about that too?
Subject, we've looked at the cases. Subject matter jurisdiction is not waivable.
I know, but that's.
We all know that, but we're not
What we're
talking
talking
about.
What the issue of a summons is what has to be done to start the case. You have to.
Thank you, counsel. You make that point in your brief. Thank you. Thank you both. People v. Sean Bryan.
Good afternoon. May it please the court, Matthew Bova for Mr. Bryan. The complainant's statements that shifted blame away from him onto Mr. Bryan were testimonial under Michigan v. Bryan. Michigan v. Bryan declares that the inquiry focuses on whether the primary purpose of the statements is to establish evidence potentially relevant for trial. If it is, then it's testimonial. On the other
Supreme
hand,
Court, of course, held that it was an excited utterance.
Yes.
Why was that not the case here?
because that disposes of the common law hearsay issue, but that doesn't dispose of the testimonial issue. Because excited utterance simply means that at the time you make the statement, you're operating under the excited stimulus, but it does not follow that it's therefore not testimonial, because someone could be excited, but as here, very clearly be aiming to create evidence for trial.
It was testimonial because Mr. Wong, Officer
Sorry,
Wong prompted him to, it was testimonial because he was prompted by the police officer to speak?
No, it's not just testimonial because it's prompted by an officer to speak.
Okay.
It's testimonial because looking at the circumstances from an objective standpoint, we look at the primary purpose of both the declarant and the interrogator together. Statements that bear on where an assailant is running off to, perhaps even statements that bear on what that person looks like. Those are the kinds of things that could help the police find an assailant at large. The critical difference here, though, is that these statements had absolutely nothing to do with that. Gilbert's statements here were about what happened during a prior incident. And what Gilbert says is during that prior incident, there was a run-in at a bar and Mr. Bryan waved a gun. So what Gilbert is doing here is he's not trying to help the police address an emergency. He's trying to offer evidence that will cover himself and deflect blame onto Mr. Bryan. That is why those statements are testimonial.
Now, at the time that utterance happened, the defendant was still at large, right?
Yes, Judge.
And he had just been shot 18 minutes prior, correct?
Yes, so he's excited, there's someone at large. But Michigan v. Bryan also disposes of that issue too, because it says the fact that there is an emergency in the abstract does not control. We have to focus on the statements. This is a completely different analysis as to things that go to perhaps just description of the shooter. That can help them find someone. That's the kind of thing that Michigan v. Bryan said was offered for the primary purpose of addressing an emergency. But this is about a prior.
Whether or not it would help the police find him doesn't determine whether it's an excited utterance.
Oh no, but we're not. But that's the we're not talking about the excited utterance issue here as to this objection. It's about the testimonial issue. For the purposes of the argument, we can see that it's an excited utterance under state common law hearsay. But Crawford and its progeny say that that's not the test. The test is whether it's testimonial. And here we have blame-shifting statements that shift blame away from the declarant and directly onto Mr. Bryan. And so in Michigan v. Bryan too, that's where someone is found on the ground and the shooter is at large. But the statements there are about the incident. They can actually help someone find. They can actually help the police. Here, Gilbert.
How do you know what he's going to say? He's just been shot, and the officer is this incorrect? Correct me if I'm wrong. He was looking perhaps to see if there was a photo of the alleged assailant on the phone of Mr. Gilbert.
Yes, that's part of what he asked.
Okay, so he was trying to do that. So why isn't that part of an ongoing emergency?
So what the officer's statements are pretty ambiguous as to his purpose. They could kind of cut either way. Just kind of ask questions like, what happened? What does he look like? But that's only half of the equation. Michigan v. Bryan says we don't just look at the police. We also look at the declarant. And this declarant is testimonial plus. Because this is not just, as in the words of
Counsel, are you arguing that after he's shot, 18 minutes later, he's concocting a defense?
I actually think the record very clearly shows that. What he's doing is He's not asked about a prior incident. He's volunteering that because he knows he just got into a fight. He recognized with the officer, I punched him. He pulled a gun out of me and I punched him, which is actually false according to the video. But then he's volunteering a statement about something from 15 minutes earlier. 15 minutes earlier about a prior incident. So Gilbert is trying to protect himself. He recognizes he's in trouble. He just really clocks someone, as that video shows. I mean, that was a strong haymaker, straight to the jaw. He knows he's in trouble. And that's why he's trying to say, this person started it 15 minutes earlier. And that's the critical issue. And no case holds that something that is so clearly blame shifting is not testimonial. Again, it's different when we're talking about the current incident. That can bear on an emergency. But this prior incident has absolutely nothing to do with an emergency. And I don't even think the government denies that if you look at his statements objectively, his statements have absolutely nothing to do with addressing an emergency, and they are geared towards prosecution.
Are you saying that there was no emergency at the time?
No, that's not what I'm saying. But Michigan v. Bryan says that doesn't control. We don't just ask, because if that were the case, if the existence of an emergency were sufficient alone to render something non-testimonial, every statement made while someone who just committed a violent offense is at large would be non-testimonial. But Michigan v. Bryan says that's not the test. The fact of the emergency is relevant to assessing primary purpose, but the existence of the emergency is not the dispositive question. And here, the government can't meet their burden of establishing the admissibility of this evidence. And this evidence was important to the government's case. This evidence directly contradicted Mr. Bryan's testimony as to whether there was a prior run-in, and the government expressly relied on it in summation in order to establish this was not self-defense, but this was revenge because Mr. Bryan was angry about the prior incident and he was not acting in justification. So therefore, the introduction of this evidence was reversible error. Thank you.
Thank you, counsel.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. So the statements in the back of the ambulance by this victim were not testimonial, and they were
Counsel,
not, yes.
Let me ask you this. When Sergeant Wong said in the back of that ambulance, quote, I'm trying to get more information, close quote, doesn't that make Gilbert's subsequent statements testimonial?
Not necessarily, Your Honor. We'd have to look at the exchanges between Sergeant Wong and Mr. Gilbert in their entirety. And this was not formal questioning by Sergeant Wong. This was not a station house interview of the sort that would produce a testimonial statement. Sergeant Wong's primary purpose, as the record of the conversation showed, was first to try to console Mr. Gilbert and calm him down as he was on his way to the hospital, having just been shot. And then he was asking questions such as the court mentioned, what does he look like? And asking whether there was a
Because they were trying to find him? Because he was still at large, right?
Absolutely.
So they're asking him, what does he look like? It's because he hasn't been arrested yet.
Correct. And I would note that
your position is that's not testimonial.
That's correct.
That's inquiry as to because the defendant is at large with a gun.
That's correct, Your Honor. And I would note that counsel in his reply brief said, well, if the sergeant had asked which way did he go, well, that would maybe be responsive to the ongoing emergency of a shooter being at large. But I'm not sure how that is so different than what does he look like? They're trying to apprehend him. That clearly the emergency was still ongoing. And
he was acquitted on the menacing.
And he was acquitted on the menacing. I mean, let's not lose sight of that.
And the statement sort of lends itself to the menacing charge.
Correct. I mean, this case did not turn on the admission into evidence of this statement in the back of the ambulance by Gilbert to Wong. The evidence here came primarily from the high-quality surveillance video of the shooting. And I know the court has that video. If you haven't reviewed it, I urge you to. I mean, it shows this shooting from start to finish. And while the motive behind the shooting or the events that may have preceded the shooting might be interesting, they really were not what this case was about. There was no dispute that Mr. Gilbert punched the defendant, that the defendant kind of reeled from that punch and then was able to push Gilbert off, and then the defendant took a number of steps away from Mr. Gilbert. And as he did so, he pulled out the gun. Gilbert was on the ground in front of the pizza shop, and the defendant pulled out the gun, pointed it at him, trained the gun at him, and fired. And the video clearly showed that. And whether that
Was the defendant in danger when Mr. Gilbert was on the floor and he was pointing the gun at him?
Not at all, Your Honor. I mean, and the defendant himself recognized that the only thing that had happened to him was that he was punched. And not to minimize being punched, but it was a punch. This was not deadly force, and it.
When you say defendant recognized it, you mean because he was searching online? What's the consequence of using deadly force when you get punched?
Exactly, Your Honor. He did that query, and he wanted to know, could he respond with lethal force to a punch? And the video shows that this was a punch, and that is what led the defendant to shoot Mr. Gilbert, and whatever might have happened 15 minutes earlier at the other location that Mr. Gilbert was talking about in the back of the ambulance went only to the menacing charge. The jury acquitted the defendant of the menacing charge, and the jury had plenty of evidence completely apart from Mr. Gilbert's statement to Sergeant Wong to decide the question of whether the defendant was guilty of shooting Mr. Gilbert and whether he was justified, as he claimed at trial, in shooting Mr. Gilbert, and to conclude that he was obviously not justified in shooting Mr. Gilbert. And I would also just emphasize, as I emphasized in our brief, that this argument, this confrontation clause argument that the defendant is making, was really not preserved. And counsel's argument here, noting the distinction between the excited utterance ruling and the confrontation clause argument, illustrates the point that the defendant did not preserve this claim at trial, because the court focused only on the excited utterance argument and did not ever rule on the confrontation clause question. And the fact that counsel at trial never pressed the court to make a ruling on the confrontation clause argument means that that argument was unpreserved. So I would ask the court to, for that reason and for all of the other reasons, to reject the defendant's confrontation clause argument, as well as the other claims makes in the brief, and to affirm the conviction. Thank you very much.
Thank you, counsel.
As for preservation, I'll just direct the court to pages 2 through 3 of the February 28th, 2023 transcript, where counsel specifically says that the statements are testimonial. The court says, what was the statement? And then the prosecutor elaborates with chapter and verse as to the precise statements that are objected to now on appeal. This claim is amply preserved. The fact that the court conflates common law hearsay analysis with the testimonial inquiry does not prove lack of preservation. It simply proves error under Crawford. The entire gist of Crawford is that that analysis doesn't control and testimoniality does control. And that was what the court missed below. As for the existence of an emergency, I mean, 367 through 368 of Michigan v. Bryan is directly on point. Our decision should not be taken to imply that the existence vel non of an ongoing emergency is dispositive. The analysis focuses on ascertaining, looking to the contents of both the questions and the answers. And here, we have questions that are either on the officer, that are either going to testimoniality or just general and ambiguous. And we have statements from the declarant that are overwhelmingly testimonial. On balance, looking at all of this objectively, which is what Bryant commands, on balance, this was testimonial. And therefore, as this evidence was harmful to the defense, as to the acquittal, The acquittal indicates that the jury perhaps didn't believe the statement regarding the waving of the gun, but that does not indicate that the jury didn't believe the testimonial component of the prior altercation. It's the existence of the altercation that really matters, because that's what shows that this was not just two strangers on the street coming up and...
Did the prior altercation happen at a bar called Pianos?
Yes, Judge.
And wasn't Mr. Cisse, the other person who was shot, wasn't he the bouncer at Pianos?
Yes.
Did he testify about
No,
what
he couldn't provide that. No, he couldn't provide that information. The information came from Gilbert. So even if we assume that the jury didn't believe the portion about waving the gun, the jury did hear about the prior altercation. And that's what changed this case from a man sitting on the sidewalk who gets clocked by two people attacking him who he has never met before and are complete strangers to a revenge-based altercation, which is what the prosecutor argued in summation. Thank you.
Thank you both. Both of your briefs were excellent, I thought. Although the people's brief was 83 pages long. Just throwing that out there.
Although what?
The people's brief was 83 pages. Okay. People v. Pedro Vega.
Good afternoon, Your Honors. Nathan Brown with the Legal Aid Society on behalf of Mr. Vega, and I'm happy to bring you a case that is much more straightforward than the last two you've heard. This court has essentially decided the issue presented here in People v. Allen. In Allen, the statute at issue was Correction Law 168F3, which this court held was unconstitutionally vague as applied.
This one involves F4, but that distinction probably doesn't matter for your argument.
Correct. The issue is that the relevant statutory language is identical, and so if the language in Allen was unconstitutionally vague as applied to a homeless offender without a home address, it's unconstitutionally vague
But
here.
preservation is the first threshold you got to get over.
It is unpreserved. We would ask Your Honors to take the issue up in the interest of justice, as you did in People v. Allen.
It's just hard to do, because in Allen, wasn't there a little bit more of a record about the homelessness status of the defendant there?
There was, and to some extent, that is to Mr. Allen's credit. In our case, there are issues that we argue go to the interest of justice in the failure to establish that belong to the prosecution. They don't actually allege at any point that Mr. Vega changed his address. They don't even
But the problem is, right, if you don't preserve, then the people can't put in that evidence. And so how can you blame, there's no preservation and therefore no record made, you can't blame the people for that if you're not raising it below, or at least with the court.
What I'm blaming them for and why
Well, let me just start with this. There's no record as to whether or not he was actually homeless, right?
There's also no record as to whether he had a new address.
Right. There might also be other things, but there's no record as to whether he was actually homeless, correct?
There's no record at all as to where he went.
Could have been living in a homeless shelter. Could have been living with a relative, but not, right? We just don't know one way or the other.
Correct.
So we could not, on this record, make an as-applied constitutional decision, could we?
We have an inference that a person living in a homeless shelter left the homeless shelter for a reason other than having another address to go to.
And we would make a constitutional as-applied decision based on that inference?
Following your own as-applied constitutional decision.
No, Allen had a lot more than that.
And the reason why the interest of justice would be served here, because what the prosecution provided as a basis for the prosecution in this case was insufficient. And so there's a slight difference between Allen here, because in Allen, Mr. Allen had the obligation to verify his address every 90 days. That's what F3 is. In F4, it's an obligation to update your address. The allegations here contained no suggestion that Mr. Vega had another address to update DOCJ with. The only allegation is that he left a homeless shelter for a reason other than having a new address. That's insufficient to support the charges here, and to my mind, an inference that he left a homeless shelter to live on the street. In our view, that is a point that goes in favor of taking the issue up in the interest of justice. I'll also note quickly that the appeal waiver doesn't cover this issue, first because it's a right of a constitutional dimension going to the heart of the process, and because the waiver here was insufficient. It portrayed the appeal waiver as a complete bar to appellate review, which the Court of Appeals has held is insufficient. While there is a written waiver in this case, The Court of Appeals has also made clear that the written waiver can only supplement the court's explanation, and because it occurred prior to the court's explanation, it could not possibly supplement the final word that the court gave to Mr. Vega, which was that he had no right to appeal. If the court has no further questions, we ask that you vacate the conviction and dismiss the information. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court. ADA Joshua Weiss for the Office of Darcel D. Clark. Defendant's as-applied challenge to the SORA provision criminalizing his failure to report his change of address is unpreserved and factually reviewable on appeal. For the reasons discussed in our brief, moreover, the claim is also foreclosed by defendant's appeal waiver. With respect,
If we found the appeal waiver invalid, that wouldn't, then we would get over that hurdle, right?
Perhaps
Are
you
you
could
argue, yeah,
perhaps-
so why are you saying that the waiver was valid?
I'm sorry, why is the waiver
Yeah,
valid?
why is the waiver valid?
Admittedly, this is certainly not the most thorough.
No, it's really not. That's
oral
admittedly
explanations coming before the
is sort of a kind way of saying it.
Right. But with that being said, I would submit that the waiver still checks all the boxes for the requirements of a valid appeal waiver. The court explains what an appeal entails. It distinguishes it from the rights that a defendant ordinarily gives up by pleading guilty, and it informs him that in this case he would have to waive his right to appeal in order to obtain the benefit of the plea being offered. Couple that with the detailed written waiver defendant signed.
I think the written waiver is what saves your bacon because
Right.
the colloquy, there's nothing about separate and apart from the rights you give up by pleading guilty, and there's not. She doesn't make it clear, or he doesn't make it clear that there are some rights that survive a waiver in the colloquy.
No, Your Honor. The court didn't list examples. The Court of Appeals has never required that such examples be provided. But I agree. I would agree with Your Honors that the written waiver here should carry a lot of weight, especially another factor militating in favor of finding the waiver valid.
Let me ask you, I'm sorry, I didn't mean to interrupt you. Let me ask you, is there any indication that when defendant left the homeless shelter that he went to the street as opposed to a relative's or another homeless shelter or any other place?
No, Your Honor. There's no indication
Anything
whatsoever.
in the record by which we could say, oh yeah, he actually was living on Avenue B in East 14th Street?
Right. In fact, Your Honor, I would submit that the record forecloses the very inference that my opponent asks you to draw. Because before sentencing, the defendant told probation that he chose not to report his change of address to avoid arrest for a parole violation. That is precisely what the report says. And in the absence of a developed record, this claim cannot be adjudicated on appeal.
Where is it the notion that he's homeless, that he's living on the street? How did that come up?
It's from all that appears, Your Honor. It's rank speculation. I would also point out two critical distinctions between defendant's case and Allen. There was undisputed record evidence based on statements counsel made at arraignments that defendant was homeless, and beyond that, the defendant there made strenuous attempts to comply. He kept reporting to criminal courts in an attempt to register his address, but was turned away with instructions to come back once he had a fixed address. Here, there's no indication that defendant attempted to comply. On the contrary, his failure to comply appears willful. So for all these reasons, I would ask the court to affirm.
Thank you, counsel.
Given that I was just accused of rank speculation, I thought I would just momentarily note that, again, there is no suggestion that he did indeed change his address. What I'm making is an inference based on somebody living at a homeless shelter, leaving that homeless shelter. But the second point I wanted to make is this idea that it is mutually exclusive that somebody can evade a warrant by living on the street. My adversary suggests that he admitted to evading a warrant, and that means he must have had a different address. You can evade the warrant just the same by living
Well,
on the street.
isn't that a fair, you're talking about inferences, right?
Yes.
Isn't that as equally fair inference? I have an address, but I'm not going to tell you what it is because I don't want to get charged with a parole violation.
I-
That's, to me, seems like an equally good inference to make from what we have at this point.
It is another inference that can be made. I just don't think it's as reasonable when you're talking about somebody living
Why
in a
not?
homeless shelter who leaves the homeless shelter for a stated reason other than having an address to move to.
What about the distinction that counsel makes with regard to the facts in Allen where that person was really trying to comply?
Sure, thank you,
Again
Heather.
and again.
There is no, the analysis as to whether something is unconstitutionally vague requires no effort in particular. The suggestions and what this court said in Allen were that a person is left not knowing what to do. And so whether somebody tries, tilts at windmills to try and satisfy the statute is no different than somebody being so confused that they do nothing. So I don't think that matters in any way. Thank you.
Thank you both. Felton v. St. Joseph Hospital.
Good afternoon. May it please the court. Argiro Dracos here for the defendant respondent, St. Joseph Hospital. We are seeking reversal of the trial court's order and granting of summary judgment as to the hospital. Our first point is acknowledged by the plaintiff respondent in that there is no basis in the law in the state of New York for hospitals to verify priority of individuals.
You're not covered by Public Health Law 4201 sub 2.
Correct. And what they're seeking to do is expand the duty of a hospital and have hospital personnel meddle in family affairs during the grieving process to determine who has priority. And that, of course, defeats the purpose of the statute itself. The hospital's obligation under the law is to notify the next of kin, which was done here. Dawn Tadeo, that information was obtained from the nursing home. She was his emergency contact, Mr. Felton.
And then the plaintiffs were notified by Ms. Tadeo through a cousin, right?
Correct, correct.
And they came to the hospital.
Correct, they did.
And they didn't leave any contact information for themselves, as I understand.
They did not, they did not. And from that point forward, the record establishes that Ms. Tadeo, the plaintiffs relied on Ms. Tadeo to make the arrangements for the disposition of Mr. Felton's remains. They were in contact with her. They knew that she was contacting funeral homes. At no point did they advise her of their wish to want a funeral or a burial, or that they wanted to dispose of the remains themselves. They acknowledged that Ms. Tadeo was homeless at the time. There was never an offer that they would pay. Everything was...
Who paid for the cremation?
Ms. Tadeo's son, who has no relation to Mr. Felton, paid for the cremation by credit card. So the hospital did what it's supposed to do. The licensed funeral director determined that Ms. Tadeo has priority under the statute. They presented to the hospital with the statement of authority, and the hospital has a right to rely on the statement of authority in order to release the remains. It's contained in the statement of authority itself that the hospital is relying on that statement.
I want to just ask you, what are the plaintiffs relying on to dispute that Ms. Tadeo is the next of kin?
So they're arguing that Ms. Tadeo is an ex-girlfriend.
Right, but based on what? I mean, are they just, is it their own, they hadn't seen the decedent in like 20 years, right?
Correct.
So
it's
they are saying, just based on my testimony, she is not the next of kin?
That's correct. That is correct. And that self-serving deposition testimony directly contradicts with their action at the time. If she's an ex-girlfriend, why is she the one notifying
Her son
you of his
pays for
passing?
right.
Why are you relying on her to contact funeral homes? Why are you relying on her to pay for the funeral? Why do you allow an ex-girlfriend to take that control? I think the lack of an action on their part I think demonstrates that they knew they had no priority.
And it's the totality of the circumstances, right? And so
Correct.
of all those things, the paying of the funeral, she's the one who was there, she's the one who did this, she signed all the documents, the only thing in that totality that's opposed to it is the plaintiff's own testimony. Yes, I hadn't seen my father for 20 years, but this woman was not his next of kin.
Correct.
And they share children, right?
They do. So Mr. Felton and Ms.
Ms.
Tadeo
Tadeo have two children together, right?
The last
But the
time-
one who paid for the funeral was not one of their shared children.
Correct.
Okay.
Correct. And each time, each plaintiff, the last time they saw their father at different points in time over the past 20 years, they all testified Mr. Felton was with Ms. Tadeo.
Okay.
There's also the issue of Adam Nazarian, one of the plaintiffs in this case. There was never any evidence offered during the course of discovery that he actually
Is a biological child.
Correct.
But if we granted the motions for summary judgment of the 3 institutional defendants, that would be irrelevant, right?
Correct. That would be moot. And there is a common law indemnification claim that the hospital does have against the co-defendants. But again, if the underlying motion is granted, then that, of course, is moot as well. If there are no other questions.
Thank you.
Thank you.
May it please the court, Melissa Friedman. I have Ackerman's Funeral Home, and we are saying that we have indemnity and immunity because when Mrs. Tadeo contacted us, she said she's his domestic partner. She made for payments, she signed the forms, and there was nothing suspect.
What forms did she sign?
She signed the at-will, she signed the cremation authorization, and there were a few other.
So that is the question, the cremation authorization. There's some dispute about that. So there's one that's signed in when?
Well, she told us that she signed them the day that she contacted us. And then.
Which was when?
February 21. And then the next day, she had her son, who's not related to Mr. Felton, make payments by credit card over the phone. But she said.
There is a February 21 cremation authorization in the record, right? Dated February 21.
21 or 22? I believe it's 21.
It's 21. I'm looking at it.
Yeah, 21.
And that's the one she said she signed.
She said she signed it.
And she couldn't get it to you because there was no fax machine in the shelter.
Correct. She sort of disappeared from us, and we called her at every number that we can find.
When did you get the February 21 authorization?
Ackerman's got it, I believe, March 11, but Greenfield, the crematory, got it on March 4th.
4th. And what you got on March 4th was dated February 21st.
Correct.
But it was Greenwood that got it on March 4th, not you.
Right, we called them, they said we got it, but she wasn't capable of faxing to 2 different places. So she faxed it to the crematorium, they acknowledged that they got it, so we were good, and then she later faxed it to us about a week later.
But there's another one signed March 11. Is that because someone gave up their copy?
There were 2 copies circulating, so my understanding is she faxed one to the crematory, and then she faxed it to us a week later. And she was just incapable of faxing. So
She contacts you guys on the 21st, you send her the form. On the 23rd, her son, and not the decedent son's, pays for it. And then you get her signed copy on March 4th.
Right. So obviously, we believed what she was telling us. We reduced our fees. Everything that's produced, all the subsequent paperwork, the death certificate, the burial form, everything is based on information that we were given from Dawn. So it's not like we saw anything that indicated that she was not his domestic
And
partner.
that shows you acted reasonably and in good faith pursuant to the statute, which is the language of the statute.
Right, because there was nothing that wasn't incomplete that shouldn't have been completed.
And there was no time that you were contacted by any of the plaintiffs before
March
Mr. Felton?
11th.
I'm sorry?
I believe it was March 11 that we were contacted.
A week after Mr. Felton's Mr. Felton's body was cremated.
Right,
And about a month after he died.
right, because she didn't contact us till like a week after he passed.
Thank you, Counsel.
Good afternoon, Your Honors. Michael Kern from McCarthy and Associates for Defendant, Appellant, Respondent, Greenwood Crematory. I'm going to, I might try to be a little.
Can I start with a quick question? Did you have an authorization from Ms. Tadeo in your hand when you cremated the decedent?
Yes, Your Honor, we
That
did.
was dated February 21, the one that you had in your hand when you I don't
Yes,
know.
we also said there was another one. They said it was the 11th. We said it was the 4th. But yes, we had an authorization.
Is there any dispute in the record that you had a signed authorization when you cremated the decedent?
No, Your Honor, there is no argument that we did not have a signed authorization. In fact, my client wasn't the only one who said that. Ackerman said it as well. And in fact, I'm very glad to hear you say this because this type of case is exactly what Section 4201 of the Public Health Law is designed to prevent. Families are complicated. Mr. Felton,
To say the least.
We know that.
especially when you have someone like the decedent Otis Felton, who had children with several different women, and I will even say more importantly, at the time of his passing, had dementia. So he can't weigh in on who, if anyone, can do this.
And Ms. Tadeo knew everything, his social security, his private information, where he lived, what was his issues.
Correct, and I think as the other attorneys pointed out, she maintained, I believe it was Your Honor, the presiding judge said that she was the one who told them that he was in the hospital, that he was even sick in the first place. And I know the lower court had said, well, the fact that she was homeless was problematic. In this case, I believe it's the opposite. Here's someone who is homeless, facing all of the challenges that provides to anyone, but yet.
And wants to make sure that Mr. Felton has closure.
Exactly, and not just wants. Finds a funeral home, signs forms.
Gets her son to pay.
Gets her son, not even from, not her, because he
Not
did
his
have
son.
Different, yes, two different children, but they did pay. Yes, so she follows through on someone who did have dementia, who she did not live with personally because he was in a nursing home. So
But she did appear at the hospital, according to the brief. She would be at the hospital with him as well.
Yes, that's
Am I
absolutely correct.
Your client also was not contacted by the plaintiffs until at least a week after Mr. Felton was cremated.
My clients were never contacted
Never.
by the plaintiffs. The ashes were sent back to the funeral home. That's also in dispute. My clients, as the crematory, we don't have firsthand contact with the clients. We deal with the funeral homes. That was in our business practices, and that was also this case here. Now when we first got the documents, there were some things that were incomplete. So a hold was placed, which was our policy. And once the necessary forms were completed, so the hold would be removed, it was removed and the body was cremated.
And is it your policy that you don't remove that hold until you get the authorization?
And all the other necessary documents as well. Yes, Your Honor.
And again, I'm just going to ask you one more time. There's nothing in the record that would raise an issue of fact that you didn't have an authorization when you cremated the deceased.
That's correct, Your Honor.
Everyone consistently testified that on March 4th, when you cremated, you had that February 21 authorization.
Yes, Your Honor.
And the plaintiffs obviously wouldn't know one way or another.
You're absolutely right, Your Honor.
So then what was the confusion? Was it because there was a second authorization signed?
That's a good question, Your Honor. I don't really see confusion here. I see this as very straightforward. The body was only cremated once we had the authorization. And furthermore, and this was a proximate cause argument I had raised, that even though the plaintiffs raised here, they did not address below, so it's really not preserved. They didn't make themselves aware to the funeral home until, now, it wasn't March 11th, it was sometime during the week of March 11th, so it's after March 11th. So even if there was an issue with these documents, which you're absolutely right, Your Honor, there is not, this is not something that we could do anything about because we don't, as we argued in our brief, I believe it's a case called Martin, we don't have an obligation to go search out family members, and honestly, nor does anyone else. So we relied on a form.
And they knew he died. They went to the hospital. They could have followed up.
All I can do is agree with you. Yes, Your Honor. I couldn't say it better myself. Other than that, I did raise some other points about motion for common law indemnity, but I will leave that for the papers in light of what the court has just said herein. Thank you very much.
Thank you, counsel. Thank you all. Providence Construction v. Silverite Construction. Please.
Good afternoon. May it please the court, my name is Scott Yaffe, appearing on behalf of the plaintiff appellant, Providence Construction Corp., and the third-party defendant appellant, Westchester Fire Insurance Company. This case arises from an MTA subcontract that promised a certified minority-owned contractor a fixed lump sum payment, adjustable only through a
The Supreme
formal
Court
change
found that there was issue of fact about whether this was a pure lump sum contract or somehow a modified lump sum contract. So that seems to me one of the issues you want to grapple with.
I'm having a little trouble hearing.
Oh, the Supreme Court found that it was a lump sum contract, but with modifications, so that the price could fluctuate depending upon the amount of materials used. Do you want to respond to that?
Yeah, it found that there was an ambiguity between it being a lump sum or a unit price contract. The only argument from Silverite is that this is a unit price contract.
Well, the price could vary, though. Didn't the contract provide that the price could vary depending upon how many units were used?
It can only vary if you follow Article 6, the change order process. That is the standard with all lump sum contracts. Everyone I've seen, I've been practicing construction law for 35 years. Every single one's the same.
But they point to Rider A, too, and say that those are two different tracks. Section 6.1 is one track, and then Rider A provides for price changes. Do you want to respond to that?
No, there are no two tracks. There's just a lump sum contract. It can only be modified through a change order, and the rider parrots the language in Article 4 of the contract, which says subject to. And in the case that we've been citing, also the third department picked up on this. You can't have a lump sum contract be subject to something and there not be a lump sum contract. It is a contradiction. It is a subject to, and that subject to language is repeated throughout this contract. So it can only be a lump sum. There is no other explanation. There's no other theory that fits all the words of the contract other than the one that we've been presenting. To rule that it's a unit price contract strikes large portions of this contract and makes it completely different than how it was written.
Well, but that's what the court found was ambiguous, and that's why you needed a trial. Let's say that we don't agree with you. Would you agree, however, that there is a issue of fact regarding the CMUs that were actually deployed by your client? In other words, is there some issue of fact, like how many, because, please, do you understand the question?
No, the parties agreed to what was done. It was very detailed.
In the contract they did, but then in terms of what was actually installed, there is a difference. And there's evidence on both sides about how much was actually installed. You wouldn't concede that, no?
No, the court below just, for some reason, completely ignored the extensive arguments in the papers and the extensive submissions that the parties contemporaneously agreed to the amount that was done. And it was done in such great detail that it was a 5-6 page, pages of...
Sorry to interrupt you, counsel, but I thought your client declined to participate in a joint masonry recount with Silverite.
Recount.
A recount, yeah, in other words, so after the job's been done, then there's a discrepancy. There's the CAD blocks evidence, I'm using the acronym, And then, anyway, so after the job was done, isn't there a discrepancy about how much CMUs were installed?
Now, CAD Blocks was hired for this litigation. They used a different method than the parties had agreed to. This, they left out, they only look at.
Difference grew out of how you count a door. The difference in the counting had to do with how you take account of a door or other opening. Is that right? Okay.
Yes, CAD Blocks is only used to determine how many bricks you need, how many blocks you need. They do not look at the total square footage. And the total square footage was agreed to by the parties. The parties were in complete agreement. They did this in estimating the job and in determining what was done. They used a standard method where you take a wall and you are going to not exclude the window or the door or doorway, because those are actually more expensive than filling them with block. So you just take the square footage and they work it out that way. Otherwise, it's way too expensive and difficult to even do an estimate. Both parties agreed on the estimating process, on what was done. This is something they made up later to try to reduce the contract.
Well, then how do you, I'm sorry.
No, you are good.
How do you explain all items noted above that contain unit quantities are subject to change up or down? That in and of itself indicates that there was no 100 this at that or 150 this at that. If the parties agreed that all items noted above that contain unit quantities are subject to change up or down contingent upon actual job quantities. To me, that seems very clear that it wasn't, we all agreed on day one, it was this at this, and there was never going to be any change. In fact, the contract makes that point, disputes your point directly.
So this is boilerplate language that you.
It's language in your contract. If you signed it, you're bound by it, right?
Well, actually, they omitted it in the first contract, and then it omitted it.
Does the contract at issue not say that?
It says that if you read it carefully, the items, it refers to the items that were changed. There are only 9 items that were set in it, and none of them address unit prices. So the clause is irrelevant.
Doesn't it say
it is a
furnish
meaningless
and
clause.
install? Let me just interrupt you. I'm sorry. I just want, because your time is, and I don't want my JP to get angry.
I would
It says to furnish and install 70,000 at this price and install 126.82 at regular block at that price. And then it says all items that contain unit quantities, which is exactly what we're talking about here, are subject to change up or down contingent on actual job quantities. And isn't that what your adversary is arguing? That you didn't put in that number at that price. You put in a lot less.
So you would have to read that as completely erasing the whole contract and most of the clauses of the contract.
The contracts are what they are. You can call them whatever you want, but the language says what it says, and you're bound by it, right?
Yeah, it is not germane. It is not relevant to, and it doesn't read out. You can't read it in a way that it eliminates most of the contract. You have to read it together with the rest of the contract. And if you read it carefully, it doesn't apply to anything.
Hey, Counsel, you can talk about that on rebuttal. Thank you very much.
May it please the court. Your Honors, Paul Bersati from Armstrong Teasdale for the respondents. Your Honors, I absolutely think you can read that provision and also the other contract. Because if you look at the background of this case, as we laid out in our affidavits, this was a design-build contract. Silverite was designing the project for the MTA's approval and then bidding out parts of the project to subcontractors. At the time the subcontract was signed with Providence, there wasn't an agreement as to the amount of masonry, and because the design hadn't been approved yet. So when the parties say that in that provision that it's subject to actual quantities, that they're specifically referencing the fact that the exact quantities were not agreed to yet when it was signed. So they took the estimations. We agreed. We took Providence's estimations. We multiplied that by the regular masonry and the glaze, and you got your lump sum contract. But what's absent from this entire subcontract is the word fixed. It doesn't say fixed lump sum. It says lump sum. And we cited the Beltrone case, where that contract did use lump sum, but it said it may be subject to add or delete quantities if they encounter bedrock, essentially. There could be an addition to the contract if you encounter some unexpected bedrock in your
How do you define lump sum then? What's your definition of lump sum?
It is the initial estimation of here's what we're going to pay based on what our projections are, but that is subject to, as the contract says, I mean, it's subject to something. It's a lump sum, but it's subject to add or delete based on the actual quantities that.
But not time or other things that might have affected the lump sum number, just how many pieces were put in.
Right, Your Honor. This was a unit, and everyone understood. I mean, there's evidence in the record, again, all inferences being drawn to the non-movement, that all parties understood this was a unit price contract. We get paid, meaning Providence gets paid for what was installed. And, Your Honor, the next clause of the clause that you read references payment for overages and shortages. So, I mean, the idea that you can't read that in harmony with the rest of the contract, I think is contradicted by the record. You absolutely can. Quickly addressing the Article 6 change order, I think Your Honor mentioned this was Article 4, which references the payment of the contract price in Article 1, and it's an important reference. It references the payment, the contract price in Article 1, subject to changes in Article 6. Well, Article 1, when you look at Article 1, the contract price, it references Rider A, which is a separate provision on add or delete quantities. So it's not simply only Article 6. That's a change that is directed by Silverite based on some unexpected part of the project that maybe both parties didn't expect.
And that did happen once during the course of this contract, right? Wasn't there an Article 6 change at one time?
There were many, and none involved masonry, Your Honor. And so, and in fact, Providence argues that the masonry actually acknowledges the masonry that ended up, the amount of masonry that was used was not according to initial estimates. Yet no change order was issued for the amount of masonry because Rider A is what controls the amount of masonry. Rider A, and the idea that the parties agreed that we would pay Providence for the amount that it installed of masonry.
In March of 2013, didn't Silverite approve change orders adding to this particular subcontract at like $500,000?
555,000.
Yeah. So what was that for, if not for masonry? I'm not sure. Maybe it's not important, but I'm just going.
I'm not, Your Honor. I'm not exactly sure what that was for. I knew we did approve change orders, but Providence acknowledges in its affidavits that no change orders were as to masonry. Okay. Your Honor, the only other thing I'd address is the counterclaim. There's this notice and cure provision of our counterclaim. If the court looks at page 647 in the record, which is Mr. O'Neill, who's the project manager for Silverite's affidavit, he notes that we did communicate to Providence repeatedly as to problems that they had in the project.
No, but you don't really, are you really arguing that?
Well, yes, Your Honor, because if you look at page 2426 of the record and 2427, there's actually letters on Silverite's letterhead, and also 2423. Those communications that were attached to Mr. O'Neill's affidavit do lay out, and it references the notice and cure provision in those letters. So if the court,
No, but there is a problem. It clearly is not what's required.
Well, Your Honor, I looked back in the record in preparation for the argument.
I'm really trying to press you hard because you didn't really even argue this.
No, I agree, Your Honor.
Then why now, all of a sudden, on oral argument, you've decided, it's a lot better than I thought it was?
Well, Your Honor, two things. I guess you're right. I did not argue that as harsh as I could have.
No, you didn't argue it at all.
I will say I referenced the communications in the brief. But Your Honor, I'll admit that I did not reference 2426, 2427. I'd encourage the court to look at that and affirm the judgment of the trial court. Thank you very much.
Thank you, counsel.
Yeah, I'd just like to quickly point out, going back to Rider A, item 4 says the price is firm, and it's a singular, and it's a firm price. So if you're going to look at even the totality of Rider A, you have to include that language and give it some meaning. Also, I want to point out we're a minority contractor. We're protected by law and by contract, by their contract with the MTA, on our quantities and our price.
Yeah, I don't know. I didn't find that argument so strong because it's a goal, to have MBEs and WBEs. It's a goal, so that's aspirational. It's not like a deal breaker with their contract with the MTA.
Well, I pointed out the language in the regulatory language and in their contract, that says they have to get permission from the MTA to make any change to their utilization plan. In the plan, they put it as a fixed price contract. They put it as a price from when they first reported it to the MTA till the last time, as a single price, and it never changed. So their argument that it's somehow fluctuating or whatever is belied by their own reporting to the MTA. They can't change their plan, and they can't change what they pay us unless they get MTA permission, and they never did that. And those rules require this to be a fixed price contract. It's a percentage of their fixed price contract with the MTA. Just to say that this is a unit price when it doesn't say anything of that sort, I mean,
You make the point very fully in your brief, Councilman.
Thank you.
Thank you. Thank you both. Finally, Associated Industries versus Feronic.
Good afternoon, may it please the court. My name is Copernicus Gaza. I represent the defendant Appellant Halpern and Pentel. We are a property manager for a site where there was an injury during a facade project. The plaintiff in this case, Associated Indemnity Insurance, sued for rescission of its insurance policy based upon alleged material misrepresentations by its insured Feronic, who is allegedly a consulting engineer on the project.
Right, and the problem is, Mr. Feronic, problem for you is he didn't answer the complaint. And so, therefore, is that an admission that he made material misrepresentations in this insurance application?
Oh, we don't view that as a problem, Your Honor, under the law, because we don't feel that the default judgment standard applies to the summary judgment that was granted against my client, Your Honor. So when there is law that says when a carrier brings a rescission case and obtains a default against its insured, other interested parties, that default is not binding upon them.
Yeah, but Justice Gesmer and I were on a case called Colony Insurance Company versus Danica Group, which seems to hold to the contrary. How would you distinguish that case?
In that Danica case, Your Honor, those two cases that this court decided, if you read down and dig down deep into the facts of that case, the intervenor defendants, which were interested parties on the reformation, did not argue the substantive merits of the rescission. They asserted claims related to waiver and estoppel, which are equitable claims, which my adversary will say I'm limited to asserting those claims here. However, that's not the holding of the Danica case that this court came down on. The facts of that case were the intervenor defendants were not direct defendants named like I am here, and they did not argue the legal merits of the reformation. They only sought to assert waiver and estoppel claims. To take that case and to lay a blanket rule that says when just by happenstance and fortuity that the named insured doesn't appear in the case, that they get to roll over on my clients and push over a default judgment standard when everyone knows a reformation of insurance policy is a high standard. There are considerable steps that have to be taken to get a policy rescinded, and none of that was even tested here, Your Honors. This was summarily decided on default judgment, and we were never given our day in court to put them through.
But you can bring a cross claim, right? You can have your claim. You can have your day in court, just not in the way that you want it.
In other words, go against Feronic.
Oh yeah.
I'm sorry, I couldn't hear.
Go against the defaulting party.
Well, I mean
You're not foreclosed from having your day in court. You have to have it in a different iteration than in this action.
We may be able to, obviously Your Honor points out that we can go after the defaulting party in the underlying case to get an allocation of liability or an indemnification, whatever the facts may be. But that doesn't change the fact that we are now faced with a order that holds that we on summary judgment, when not one test has been applied legally by the court, that somehow applies to us, and it's just a matter of fortuity, Your Honors. It really, had he appeared in the case, we wouldn't be standing here today. But there is case law we cite, especially in our reply brief, that says where...
Only on your reply brief.
But it goes to the issues, Your Honor. It goes to the issues that were raised in the respondent's brief. So that's really where we stand today, Your Honor. We believe that we're entitled to have our day in court on summary judgment.
Why is the remedy not suggested by Justice Scarpula completely?
I'm sorry, Your Honor.
Why is the remedy that Justice Scarpula suggested not totally adequate?
I'm having a hard time hearing.
Why is the remedy that Justice Scarpula suggested totally adequate to achieve your objectives?
It's a separate remedy. We are claiming insured status under the policy
I understand
as well.
it's a separate remedy, but why isn't it an adequate remedy?
Because we're seeking status as an insured under the policy, Your Honor, where we'd be entitled to a defense and indemnification from the carrier. We're claiming to be an additional
Couldn't you
insured.
obtain that by the alternative remedy?
No, Your Honor, that's not in the underlying case. The issue of insurance is not at issue in that case. As a matter of liability and damages, we can try to certainly shift the loss to the defaulting Feronic in the coverage action. In that case, yes, this is an insurance coverage case where we're seeking insured status and a defense and indemnity under the policy.
Right.
So it's not adequate, Your Honor, to seek that remedy. It might be semi-adequate where we can shift it, but we're entitled to a full defense and indemnity from the carrier, not maybe a partial allocation on damages in that case. So that's why we're here today. I'll yield the rest of my time on that. I think Your Honors know the issues, but we believe that we're entitled to have the order reversed. Thank you.
Thank you, Counsel.
Good afternoon, Your Honors. Max Gershwire for the respondent. First, I want to address the argument that the colony decisions that the court handed down are not applicable here, based on the idea that the defendants in that case, the appearing defendants, did not argue materiality. That is not true. If you look at the record in the second colony case, which Your Honor, Justice Moulton and Justice Gesmer were on, they did in fact argue that. And I'll quote from the record, page 44 of the record of that case. This is from the intervener defendants. The issues of materiality and waiver are precluded as a result, this is the lower court. The lower court order says that, I'm sorry.
Well, let me just, while you're looking for
got it,
that, may I ask you, how do you jibe that with the cases that say that you're not, the other defendants, the other direct defendants are not bound by the default?
Right. Though, other than a lower court case that was cited in the reply brief, those cases are not rescission cases, right? Those cases involve the interpretation of an insurance policy, right? So it's talking about contract interpretation.
Isn't that what we're saying? Isn't that what you're arguing here, that it's null and void? Oh, I see what you're saying. Yeah. Okay.
That's the distinction,
Okay.
right? So we're talking about rescinding a policy so that it's invalid from the get-go, from the outset. It's not a question of contract interpretation. So that would be the
You're saying those cases only had to do with the contract?
other than a lower court case that was cited, which, I don't really understand why they didn't follow this court's lead in the colony cases, but that's the only authority that was cited in the briefs from my adversary. I'm sorry, I did find the part of the record that I was talking about in the colony case. This is from the underlying brief of the intervener defendants.
Brief?
Right. Given, I'm quoting, given the procedural posture of this case, Danica, which is the named insured under that policy, is not in a position to contest Colony's allegations that its insurance applications contain misrepresentations. That does not, however, relieve Colony of having to make a prima facie showing that the misrepresentations were material, which is a threshold matter that has to be overcome for this court to even consider awarding summary judgment subject to the parties opposing the motion showing triable issues precluding it. So they did argue that issue. And the lower court, in its order...
But you're saying that the fact that it didn't matter that they were interveners, they're arguing the same thing the counsel is arguing here.
That's right.
That you have to match the higher standard regardless.
Exactly. And the lower court, which this court affirmed, said, and I quote, the issues of materiality and waiver are precluded as a result of Danica's named insured's default and thus unavailable to the interveners. That is what was affirmed by this court in the second case. So that purported distinction simply is not so. Going to the issue of the equitable defense of waiver, as stated in our brief, this court has found that where a claim is presented to the insurer before the insurer learns of the grounds for voiding the policy for misrepresentation, its only option is to cancel the policy prospectively and seek judicial intervention to void the policy from inception. That's exactly what my client did here, and so there's no basis for the waiver claim either. If there are no other questions, I'll rest on my briefs.
Thank you, Counsel.
Just briefly, Your Honor, the distinction that counsel drew between cases cited by the trial court on my reply brief that they involved declaratory judgment as opposed to rescission, I don't think there was any articulated distinction to that difference. I think it's just a matter of insurance coverage as a whole, and I think if this court wanted to make a pronouncement as strong as counsel seeks to have this court have made, that where a defaulting insured, where there's a defaulting insured, that default judgment effectively applies to other interested parties under the policy. I feel that this court would have said so. The court did not do that. In the 6 paragraphs total of the 2 cases, this court had opportunity to make that pronouncement, decided not to do so. So the other case that we cited, and I would just say briefly, just going back real quick to Danica, I'm not sure I could follow completely counsel's argument made out of the record below and out of the brief below. That's not in our record here. I did not dig down on NICEF and pull all the briefs in the underlying case. But I know what this court held in Danica. It was that the new evidence cited by the defendant interveners provides a potential equitable defense. So it's my reading of the case is that is what was presented by the Danica interveners in that case, as opposed to what was argued by counsel here. So with that, I'll rest on my papers unless the court has any questions they'd like me to address.
Thank you, Counsel. Thank you both.
Thank you, Your Honors.